Thank you, Steve, and thank you to all of you for being here and for being part of this conversation. This is a wonderful opportunity for all of us at the Brennan Center to advance this work, to think really hard about the Supreme Court, about the role it plays, about the role it must play, and what we can all do to stand up for the Constitution. We do this work in a really vibrant and full Washington, D.C. office, which I hope you all have the opportunity to visit. And we do this work as well through the Kohlberg Center on the U.S. Supreme Court, which is something we began 2 years ago and is a full functioning hub on the Supreme Court, on Supreme Court reform, and understanding, again, this really vibrant, vibrant we hope, and often inadequate public institution. And thanks to all who have made this work possible. We're having this conversation, I think, at a propitious time. We've just finished marking and celebrating our nation's 250th anniversary of independence. And it was 250 years ago at the founding that Thomas Paine in Common Sense wrote, "In America, the law is king." And we are finding out if that is true. And we are doing our part as patriots to endeavor to make sure that it is true. And in any such effort, a strong, independent, principled, effective, and properly functioning Supreme Court is vital. We want it to play its role. We don't want it to play beyond its role, and we need it to do what it should do. And the Supreme Court, as we all know, has vast power and minimal accountability. The portion of the Constitution dealing with the federal courts and dealing with the Supreme Court is only 1/10 the length of the parts dealing with the democratically elected and accountable branches. The court has the power that it has in our system only because it has earned it over the years and decades, only because we give it that power. And unfortunately, it must earn that trust over and over. And in recent years, we would submit that it has squandered that trust. We all know that public trust in the court, public confidence in the court, has plunged to the lowest level recorded over many, many years. And this is a function not merely of a public that is, without question, angry about government and institutions in all realms, but specifically also concerned about the direction of the court and what it needs to do. So this conversation is an opportunity to ask what the court ought to be, what this most recent term tells us about the court, how it fits into the recent several years of this supermajority of justices doing as much as they are to remake the Constitution, and what we can all do about it. We're also having this conversation not just after the fireworks and the festival on the Mall, but of course also shortly after the end of the Supreme Court term. How are we going to remember this term? I think we're going to remember it, of course, and we'll hear about this for Louisiana versus Calais, which effectively demolished the Voting Rights Act, leaving it, as Justice Elena Kagan said, all but a dead letter. We're going to remember it as well for near misses, such as when the court ruled that a president cannot Sharpie birthright citizenship out of the Constitution, but only by one vote. Vice President J.D. Vance said that that protection is hanging by a thread. And I think as well, and we will certainly hear about this, that in the broadest scope and the broadest perspective, we're going to remember this term and the other recent terms as a time when this supermajority of very conservative, very pro-business justices bent the shape of American government. I have argued that it was a power grab in legal garb, giving new power to the presidency, taking away power from Congress, and often giving that power to the federal courts, but especially to the Supreme Court. And we're going to hear about all of that, debate all those issues, debate the role of presidential power in this term, where the court has stood up independently, where it has not, in the first panel. And we really have an extraordinary panel, as you're about to hear, of really thoughtful and leading experts on all of this. And then we're going to have the second panel. All of that brings us to the second panel. because there's a lot, if we are unhappy with the direction of the court, if we are unhappy with the functioning of the court, if we're unhappy with the role this court is playing in our country, upholding our Constitution, there is a lot we can all do about it. There is a cycle throughout American history. It's after periods of abuse, it's after periods of corruption, after periods of scandal or of decay. That is when you get times of reform. Not always, but when it happens, that is when it happens. And it's unquestionably the case that there is a public demand for action of that kind, a public demand for rebuilding and reconstruction and renewal across all of our public systems. And you just heard Steve Spalding mention the solutions publication we gave you all on the Supreme Court. We have been busy thinking through some of these reforms in other areas, whether it's in corruption and the executive branch and executive power, or actually how to strengthen Congress so it stands on its own 2 feet as the branch it needs to be in our government. And there is no question to us that in this period of creative change that has to happen, a period of ferment and renewal, we have to include the U.S. Supreme Court as part of that project. We need to take seriously the need and the ability to reform the Supreme Court. We always point out that the justices wear robes, but they are not wizards, and they are not religious figures either. They are government officials who we've entrusted with a great deal of power, government officials with lifetime terms, unelected government officials who every June tell us what kind of country we live in with their pronouncements, and increasingly with what we regard as their dramatic and even radical reshaping of the constitutional order. Congress, to a far greater extent than is often understood, and really to a far greater extent than even we internalize, Congress has great unused power when it comes to the Supreme Court. The Constitution gives Congress enormous authority over the court. As Justice Kagan said, responding to Justice Alito, who said Congress has no such power, she said, it cannot be just that the Supreme Court is the only institution that somehow is not subject to checks and balances from anybody else. We're not imperial. That is a good credo to understand the role that Congress can play. Now, what can Congress do? That is really what the second panel is going to discuss, and I assume as well and hope and expect we will hear from Senator Whitehouse as well. Congress can step up. It can step up by responding to decisions it regards as misguided. It can step up by the way it drafts laws. It can step up with constitutional reform, but it can emphatically step up as well by setting the rules and finding reforms that affect and improve the Supreme Court itself. This is a time when there is new and growing and very significant political momentum for action on Supreme Court reform in ways that I've not seen before on this issue. There's a disenthralling that has happened. Examples include the fact that after the Calais decision gutting the Voting Rights Act, the very first statement issued by the Congressional Black Caucus, which has enormous, among other things, enormous moral force in Congress, the CBC said the answer was term limits for justices to help restore independence and neutrality and legitimacy to the court. We see this kind of momentum in other political leaders in both houses of Congress and across the country speaking out about this in ways they have not before. Leader Hakeem Jeffries, a couple of months ago, said that at this moment, when there's so much disquiet and so much of a need for change, he said we need massive campaign finance reform, massive electoral reform, and of significance, massive Supreme Court reform. That is very significant to have him in his role and others, as we'll hear about, stepping up and actually thinking through what kinds of reforms, what kinds of changes there can be. And we see this kind of momentum from the public as well. As we discuss these issues, it's important to note and understand, and this again is often a pleasant surprise to people, Supreme Court reform is widely popular with the public across political spectrum, across ideological and partisan divides. The most recent Fox News poll showed that 78% of the public supports an 18-year term limit for Supreme Court justices, just to give one example. That is obviously a lot of Republicans and independents as well as Democrats. None of us are under any illusions that this broad public support will translate into, a hug it out love fest when these issues come before Congress or in the halls of power. But there is public demand, and there is public support, and there is room to act, and room to rethink, and room to be creative, and room to be ambitious. It's an exciting time to have this conversation. It can be a disquieting moment as we look at what the court does and doesn't do, the ways it has and hasn't stepped up to its responsibility, and all the other ways we're seeing the constitutional order out of whack. As we look at the repeated assaults, we believe, on the rule of law, on what OMB Director Russell Vought has called the post-constitutional order, it can be very disquieting. But if we take the opportunity not just to bemoan what we see, but to act, to understand the need for reform, to talk about the things we're going to be talking about today, this can be a time of renewal also. I mentioned Thomas Paine. At the end of Common Sense, he wrote, "We have it in our power to begin the world all over again." That's what they did back then, and we have the chance and the duty to do the same thing. And as we do that, understanding the Supreme Court and understanding what we can do about it has to be a big part of that. So we're really thrilled to have you all here, and we're thrilled to have all of you. And I will happily turn the conversation over to my colleague, Dr. Kareem Creighton. He is a political scientist, a law professor, and the vice president for our Washington, D.C. office at the Brennan Center, as well as the leader, as you can read about, of our partnership for Southern Impact and much more. Kareem Creighton, thank you.
Thank you so much, Michael. Thank you, Michael. Hopefully everyone can hear me. Good afternoon. Thank you, Michael, for that great set of comments to set the framework for today. Thanks to all of you all for joining on rather humid July afternoon in Washington, D.C., and those who are listening on the internet, online. Thank you for joining us, hopefully in cooler climate. We are in this panel going to do a little bit of backward looking now, 2 weeks after the close of another blockbuster term at the United States Supreme Court, to get a sense of what the court has done and what the country looks like as a result of it. And hopefully in that last 2 weeks, we will have the 2 weeks that we've had time to reflect, we'll have some insights to share with you to get a sense of what we can expect in the years to come, both with respect to what the court's going to do, and as Michael suggested on the second panel, what we might do in order to improve the function of the court. Obviously, we're going to speak here on this panel for just about an hour, so we're not going to be as comprehensive for the entirety of the work that the court has done over the term. So our channel will be a little bit narrower, a little more deep, and we're going to go into some of the work that the court has done to help us understand its view of the United States Congress, the first branch of government as the Constitution is concerned. Themes, as Michael hinted at earlier, that we're going to think about are Congress's power to legislate for national policy purposes, Congress's power to set the structure for government, including administrative state. And then finally, Congress's power under the Constitution to give meaning to what we understand to be the Reconstruction Amendments. Now that's, still a lot of work to do in an hour, but thankfully I have three wonderful legal experts who have a great deal of expertise and experience who can help us understand how we should think about the decisions of the court. Their scholarship, their policy, and their practice have all figured prominently into the work of the court, and more than that, the policies that apply that have given rise to some of these cases. So I'd love to introduce each of them now. I'm going to start on the far end from me by introducing Arti Kohli, who is the executive director of the Asian Law Caucus. Arti was one of the principal counsel on the birthright citizenship case. Next to her is Ilya Somin, who is the professor who is a professor at George Mason University Law School and the Kenneth Simon Chair in Constitutional Studies at the Cato Institute. And Ilya will have much to say about the tariffs case because he was significantly involved in that case. And finally, next to him is Michelle Goodwin, close to home, a friend of the Brennan Center, long time. All of them are different effects, but Michelle is a Poland Fellow currently at the Brennan Center, and in her day job is an endowed professor at Georgetown University Law Center, where she specializes in constitutional law and health policy. So please join me in welcoming all three of our wonderful panelists. And just as a side note, you may have seen in earlier materials that former Assistant Attorney General Kristen Clark, another friend of the Brennan Center, was unable to join us because of some schedule changes, but she sends her best. I will do my best to offer some commentary on the case that she was focusing a lot on, which is Louisiana versus Kelly. You heard a little bit about it earlier. Our purpose here is to talk for about 45 minutes. I've promised our panelists that we'll keep it very light. I want you to hear from them and not from me. And what we'll then reserve for at the end is about 15 minutes of questions that come from you, the audience. I think our wonderful communication staff will be receiving questions, so please be thinking of them as we're talking, and we'll include them to the extent that we can at the end. So with that, I'd love to start with Ilya, who I'm going to call the shot caller on this on this panel for today. Insofar as Ilya had a very early, I think, involvement in the tariffs case, the tariffs case being among many, the learning resources case. That case involved a congressional statute, the International Emergency Economic Powers Act. I had to write that down. I didn't possibly have the capacity to remember. But that case, of course, challenged the use of the president's authority to invoke tariffs. I wonder, as you were thinking about it, can you tell us what you thought when you first heard the president make that announcement and how that thought led to the case that the Supreme Court ultimately decided this term?
Sure. So the president.
You want a microphone?
Where is the microphone? There it is. Okay, there you go. Can you hear me now? Excellent. Is it turned on or?
It is.
Great. Okay. So when the president first announced it in February of last year, he was using the statute known as IEEPA to impose massive tariffs on Canada, Mexico, and China, supposedly to combat fentanyl. I had expected that he would impose vast tariffs, but I didn't know that it was going to be under this law. So when I looked at this law, I noticed first, as others had as well, that it doesn't actually even mention the word tariffs or any synonym for them, and also that the authority they claimed under that law would enable the president to impose tariffs without limit on any country for any reason, for any amount, for any length of time. And it occurred to me that this surely violates the major questions doctrine, which says that if the president claims vast power over an economic or social issue and says that's been delegated to him, that at the very least, it has to be clear in the face of the statute, and it also violates non-delegation, because if there are any limits to delegation at all, then they have to preclude an unlimited power to impose any tariffs he wants for any reason. I wrote a blog post saying people should challenge this on the basis of these arguments. Eventually, that was seen by people at the Liberty Justice Center, a public interest law firm. They said, we want to bring this case, and they emailed me and eventually agreed that I would help them do it. More, much larger tariffs followed, the so-called Liberation Day tariffs, and I wrote a follow-up blog post recruiting clients for the case, which we eventually got, including VOS Selections, a wine importer that became our lead client. And to make a long story short, we filed the case in the U.S. Court of International Trade. We won there. We then went on appeal to the Federal Circuit, where we also won. And then finally, after we were joined by some additional people like Neil Katyal, who argued the case in the Supreme Court, we also prevailed in the Supreme Court 6-3. And I'm sure later we will talk about the results of that and the doctrine that came out of it. But we were able to prevent what was the highest U.S. tariff schedule since the Smoot-Hawley tariffs that massively contributed to the Great Depression, because the tariffs in this case were 10% tariffs on goods from virtually every country in the world, plus additional so-called reciprocal tariffs imposed on 50 or 60 other nations, which weren't actually reciprocal at all, because in many cases they applied even to countries that didn't impose any tariffs at all on U.S. goods.
So let's get into that now, actually. So we will hear a lot of commentary about how many cases the justices have offered that have essentially acceded to the president's assertion of authority. This is one place where they did not. Talk us through the court's assessment of why, under this regime, the president didn't have the authority to invoke the tariffs that he's asserted.
Sure. So there's a 6-3 decision by the Supreme Court. We had about 6 different arguments as to why what the president was doing was illegal here. I thought all of them were good. Personally, the Supreme Court focused on 2 of them. All of the justices in a majority agreed that the simplest resolution to the case is just that IEEPA simply doesn't authorize tariffs at all because the word tariff isn't mentioned. Neither is a synonym like duty or impost or tax. And historically, both in statutes and in the Constitution, the power to impose taxes is separate from the power to regulate commerce or regulate any kind of activity. So IEEPA does grant, in some circumstances, a power to regulate imports, but not a power to impose tariffs. In addition, the 3 conservative justices in the majority ruled in part based on the major questions doctrine, which, as I said before, states that when the president or the executive branch generally claims a delegation of power from Congress over some vast social or economic issue, then at the very least, it has to be clear on the face of the statute that that delegation happened. Here, at the very least, it's far from clear. And it's also obvious this is a major question. Indeed, this is probably the biggest major question any of us have ever seen, unless you're old enough to remember the 1935 Schechter poultry case, where FDR claimed an even bigger delegation than this one, but this would have been something like $1.7 trillion in new taxes on Americans over 10 years, massive damage to U.S. and world economy, and huge effect. It makes even Biden's loan forgiveness case from 3 years ago, where about $400 billion were involved, that even that seems small by comparison to this. So those are the 2 major grounds for the Supreme Court's decision. And I would add also that all of the justices in the majority in different ways emphasize that it's impermissible for the president to have unconstrained power to impose tariffs. And I think that part of their reasoning applies to further tariff power grabs that we've seen since then, like with the new Section 122 tariffs, that the president cannot simply say that some statute gives him a blank check to impose almost any tariffs he wants. And I don't know for sure, but I hope that that will be a significant precedent for the future.
So speaking of the future, I'm interested in the fact, Michelle, that there was an interesting configuration that Ilya pointed out and the justices that supported this view. Did that configuration surprise you? And what does this decision, if you, in your mind, say to Congress and others who are thinking about the future of tariff and position?
Well, if we keep in mind this Supreme Court's deference, as Michael was mentioning earlier, to big business, to economic concerns, we can see a through line. And so it wasn't necessarily a surprise. And I wanted to point to Gorsuch's concurring opinion in this case, because it raises a very important matter with regard to the court and its consistency with regard to the theory of the unitary executive, right? Because you see so much deference on that theory from the Supreme Court and its supermajority. But you see a kickback against that, by Justice Gorsuch in his concurring opinion. And he was part of the majority in this decision. And he made very clear that what Trump did was to run roughshod, if you will, against Congress, and that Congress plays a very important role in the checks and balances that we expect from a government where there is a Supreme Court, where there is the president, and there is a Congress that must be consulted. And what Gorsuch said is that essentially, it would do well by the president to sometimes pay attention to Congress. He wasn't as firm as he could have been, but it was worth noting that concurrence.
Yeah, a strong, very separation of powers based argument that, doesn't seem to be shared by the court. But Ilya, you have a thought about that?
So 2 thoughts. One is, I'm sure we'll talk much more about unitary executive later in this panel, but I think unitary executive is a term that's sometimes used to mean two very different things. One is a theory about the distribution of executive power. Whatever executive power there is, the theory says it has to be in the hands of the president rather than somebody else. But there's also a separate issue about the scope of executive power. How much power should the executive generally have? And Gorsuch, I think, here is actually being consistent. He thinks the executive should be unitary in terms of distribution of power within the executive branch, but he also thinks, both in this opinion and in his concurring opinion in the Slaughter case, that the scope of executive power should be relatively narrow. And in this case, the power to impose tariffs is in Article 1 of the Constitution, enumerating Congress's authority. There's no power over tariffs in Article 2, where you see the president's power, and therefore Gorsuch, I think, quite rightly said, the president doesn't have this power, and there are limits to how much of it Congress can delegate to him. That doesn't mean he's necessarily also right in Slaughter, but I do emphasize that these are
Absolutely.
As for big business, some big businesses like tariffs, others do not. And I think it's a mistake in many issues to think there's like a unified big business interest. In many cases, there are big businesses that benefit from regulation and consumers that are harmed by them, or vice versa. And this is actually one of them. Consumers are actually the biggest victims of high tariffs.
They certainly are. And I think that was what came through with this case.
So I want to switch briefly. We'll probably, as you know, we'll come back to the conversation about the unitary executive theory, because I think on the other side of every one of those assertions, which I think Ilya is hinting at, is a question about what Congress's role is and if they're overlapping or not. But I want to get to another area where the president's assertion of power has also become relevant, and that's the birthright citizenship case. And I know, Arthur, you were very involved in the preparation of the argument in favor of the plaintiffs that challenged the president's assertion of authority here. I guess I'm just going to start with a general question related to the earlier one we offered. Did the outcome of that decision supporting the traditional understanding of birthright citizenship surprise you at all?
I will say, the narrow majority on the constitutional question, basically you had 5 justices in the majority, Roberts, Barrett, Kagan, Sotomayor, and Jackson, who said that the 14th Amendment says what it means, and that if you're born here in America, you're a U.S. citizen. That it was only 5 of them who said that was pretty shocking. How many people here are attorneys? So quite a few. I mean, if you think back to law school, was it ever a question that birthright citizenship is the law of the land? Not really. You're questioning it in law school now, right? So, yeah, wow. So, I'm relieved. And I have to say, we were prepared for other outcomes. You cannot rely on this court.
So I know you must have had a lot of thinking with the team early on about how to approach this court that has now raised a question that you thought, and I think many of us thought, was sort of a settled matter of law. Take us inside to think through how you thought about making an argument that would be persuasive.
Well, no, it's not just even the making of the argument. It's like, if you think about how this issue came up, right? So think back, Inauguration Day. This was one of the first executive orders. And at that time, there were multiple cases filed. The case that went up to SCOTUS that first time was the CASA case. They didn't address the issue. They could have. They left the door wide open. What they made a decision on was universal injunctions, and basically said, district court judges, you cannot, except in certain circumstances, issue an injunction that applies to the whole country. So one of the exceptions was a class action. So we filed our case that day that the decision came out with the ACLU, and obviously, you know, Cecilia Wong of the ACLU argued the case, my colleague, and she's amazing. So our case was filed as a class action, and we got an immediate injunction. So, you know, birthright citizenship executive order never went into effect, though it kept, you know, being an open question. So now we're more than a year and a half in to a narrative that never had arisen, right? And so all of a sudden you have policy arguments being made on this when this is a legal question that was very clean and simple. The law was never in doubt. What was interesting is the administration really wanted this in front of the Supreme Court. We never even made it to the First Circuit. Normally, you know, a case is making its way through different layers of appeal. This went straight to SCOTUS after the district court decision. And so, because this president thinks, and, you know, he showed up at oral argument,
Which was
The
highly
historical
unusual.
first, yeah.
very unusual, right? And he's like staring at the justices with a scowl. I was there. And so, it was, I think this has all been manufactured. I think in terms of the way the decision has been playing out, they've now opened this door, right? They think. We say, the issue is settled. Congress cannot legislate, something. I guess they could do a constitutional amendment to overturn the meaning of the 14th Amendment, but that requires 2/3 of each of the House and the Senate. It requires 3/4 of the states.
So, Michelle, you had some thoughts.
Well, I think it's important that we think about the times in which we're in which the oral argument took place, in which the decision is rendered, not in a vacuum and not in isolation. We're talking about this discourse at a time in which Americans were gunned down in Minnesota, just as fact.
Yeah.
Just as fact, with a backdrop of the question of who belongs and who doesn't belong. I actually we were just talking about Minnesota because I was a member of the faculty at the University of Minnesota. And the Minnesota became a sister state, if you will, to welcome Somalians, right?
Yes.
So this attack coming at a time in which there were cities, in the Twin Cities, there were states that said, well, we actually pick a country in the world and the immigrants are coming in, refugees, and we welcome you. We want you here. During Republican administrations, Democratic administrations, didn't matter. So the backdrop of this playing out about who gets to belong, who's a citizen, this idea that the president can rewrite the Constitution by Sharpie, as Michael mentioned, comes at a time in which Renee Nicole Good is shot in her car, and Alex Preddy is shot multiple times. I actually was out of the country at the time in which Alex Preddy was murdered. And I couldn't help but also think of my husband, actually, who happens to be a tall, thin white guy, too. Mm-hmm. And as this tall, thin white guy is kind of flipping around trying to protect whomever is behind him, and he's swarmed by these individuals and murdered while people videotape. And it struck me that this is also the place that just a few years before was the death place of...
And now you've got me on the spot.
Exactly.
Yeah.
Yes,
George Floyd, yeah.
George Floyd. So anyway, there's a lot to think about.
And I will say part of the reason we joined the case is our office is a few blocks from where Wong Kim Ark was born. And that's the 1898 case where the Supreme Court addressed this issue of birthright citizenship. And we're in that same moment, right? Where this is an anti-immigrant moment. It's the rhetoric, even the rhetoric around birthright was a lot of anti-Chinese rhetoric, right?
Can I get right back
Yeah.
to you on this point? Then I will
Yeah.
get to Ilya. I asked you earlier about how to argue this, in part because all of those elements are important and really crucial to understanding what was going on.
Yeah.
I'm interested, though, particularly because we know this court seems to truck in originalism, however defined.
Right.
And this seems to be a place on its face where there are words, as you say,
Right.
in the Constitution that say a thing. And we
Right.
think,
Yeah.
both based on the words and the practice, that it means a certain thing.
Right.
How did you address
Yes.
that
So
in this case? Yeah.
so obviously it was three pieces. One was common law and jus soli, right? That's the history before we even get to the text of the 14th Amendment, right? So and this is what the majority opinion really talks about, how there was this history even of birthright citizenship, except for people of color, right? And then you have, and Black people in particular who had been enslaved. So then you have the 14th Amendment, right? And so we obviously talk about the history of the 14th Amendment and also Wong Kim Ark and what it means.
Yeah.
Right. So those were the three pieces. Plus, we actually made an argument that if you don't rule on the 14th Amendment, there's a statute, a congressional statute, which was both in 1940 and 1952, where at that time when Congress was debating the language, they knew exactly what they were doing. And so those are all the arguments that we put forward.
Yeah, thank you for that. I think
Yeah.
both of those points, the context in which this case is being heard, and also the language that we're working with is relevant. Particularly, I'm glad you brought it up, Arti, the work that Congress did subsequent to the adoption of the 14th Amendment to give meaning to it.
Yeah.
Ilya, you had some thoughts about this one as well?
First, I would commend Artie for important work on winning this case, certainly an important achievement. Second, I think there's an interesting irony here about originalism and living constitutionalism, because you see a little bit of a role reversal here that, at least for much of modern American history, I'm oversimplifying, but roughly you see sort of the political right promoting originalism and the left living constitutionalism. Here, and with many of the arguments, you almost see a reversal. Like, the supporters of the side that ultimately won made him said, well, this was decided back in 1868. And in 1868, it was clear everyone born in the United States was supposed to have birthright citizenship, except those not, quote, subject to the jurisdiction of the United States, and subject to jurisdiction or not subject to jurisdiction had a very narrow interpretation, only applied to a narrow range of people. Whereas if you look at the dissent by Justice Alito and also the concurring opinion by Kavanaugh, where he agreed with Artie's statutory argument but not her constitutional argument, he says, well, we have to consider things like illegal migration, where which there wasn't much of an 1868. He's actually wrong about that, but it's notable that he says that he says that, and then Alito talks about birth tourism, and he says, well, we didn't have birth tourism in 1868, and our interpretation of the Constitution has to take account of this new problem. So it's the kind of thing that sort of left liberal living constitutionalists traditionally argue in a variety of other cases. So I note the role reversal, and I think it's notable how it came out. In this case, the originalist arguing for the majority was so strong that if you look at a dissenting justice, even they aren't actually endorsing the entirety of the administration's position. They're just saying, well, we can't strike all of the order down because there are some of the people that it covers that might not be subject to jurisdiction, and they're not always precise about exactly what groups of people those are. But they do have a kind of, you might call it sort of right-wing living constitutionalism, which I don't agree with, but which is notable sort of the methodological reversal here. And obviously, as Michelle suggested, this is tied to a general sort of anti-immigrant political movement. But we've seen before in American history, as Jack Balkin, professor at Yale, famously put it, arguments that go from off the wall to on the wall because they get embraced by a political movement. This happened with cases like desegregation and same-sex marriage and some other things where I think it had good effects, but the arc of history doesn't always bend towards justice. And in some cases, movements can arise that bring bad arguments or problematic ones on the wall. I think this is one of those cases, but it's notable that It's easier to reject it if you stick to originalism, unwiving constitutionalism. Whether you think who you think should win in this case depends to a large extent on what you think about immigration more generally.
So, Michelle, go ahead.
Really quickly, a bit of a coconut shell game that you have here with regard to how we actually understand the Constitution and the Reconstruction. There is a very important point that could be made, which is that there is actually a form of unanimity that comes through this court, both majority and dissent, but otherwise does not seem to apply to this conservative majority. And that is an understanding that you get out of this case that the Reconstruction actually did apply to people who were formerly enslaved. Right? And that, newsflash, and that the 13th Amendment, 14th Amendment, then 15th Amendment specifically had race consciousness in it because of the facts on the ground at the time, right? And so that's actually something that you get coming out of the dissent, which you otherwise do not see in Calais or any of the cases coming out of the conservative majority over the last few years, as we've seen a robust dismantling of what were the vestiges, the echoes of cases that sought to pay some attention to that, both in terms of race, clearly, but then we can also talk about what that means in terms of sex.
Yeah, I want to definitely get to Calais and that point in a moment. And before I call on you, Ilya, I wanted to note to those listening on live stream, please feel free to text your questions so that we can capture them and include them in the process when we turn to that segment of the discussion. But Ilya, you had a comment.
Yeah, I can't resist because I wrote a whole article on this very point, which is that Michelle is absolutely right that the purpose of the citizenship clause, at least the main one, was to grant citizenship to freed slaves, but also to blacks in general, because recall that the Dred Scott decision had said that not just slaves, but even free blacks could not be U.S. citizens under what I think was a very wrong interpretation of the original Constitution, but that's what they said. Now, it is also true, as I explained at some length in my article, that if you look at all the arguments for the administration's position in this case, every single one of them would have the consequence that all or most or at least a large number of freed slaves, or in some cases free blacks, also would not be entitled to birthright citizenship. I won't go through all these arguments, though my article is in Lawfare and available for free, but I'll just mention one, that if the argument is that people who entered the United States illegally are then not under the subject to jurisdiction of the United States and therefore their children aren't either, that would have been true for many thousands of slaves and their children, because the United States banned the Atlantic slave trade in 1808, but sadly there continued to be an illegal slave trade which brought in many thousands of blacks from Africa and made them slaves between 1808 and in the 1860s, and Congress was well aware of this situation, and all of those people on that theory would not be entitled to birthright citizenship. And you can go down the list of their other arguments about domiciles and allegiance and the like if allegiance is the argument that people who voluntarily switch allegiance to the United States, they're entitled to birthright citizenship, but others are not. Certainly, slaves never sought to become people have allegiance to the United States, and so on. So every one of those arguments has that weakness. That said, there is also an issue I'm sure we'll discuss later about whether the racial aspect of Reconstruction was to be race neutral and eliminate racial discrimination, or whether some types of racial discrimination are still permitted depending on the purpose for which it is done.
Well, I'm going to take that as a cue to take a little bit of a detour and get into the conversation about the Reconstruction as it let's say, manifests itself in the conversation in Louisiana versus Calais. You have nicely described in the birthright citizenship case the contestation over the origins of the Reconstruction Amendment. I think now we're in Calais raising questions about whether or not there's an end to it. You see this court make in Louisiana versus Calais a pretty interesting procedural move, to Artie's point, that is a little unusual. In the prior term, the Supreme Court heard a case that was out of Louisiana, testing the application of Section 2 of the Voting Rights Act and whether or not it required the state of Louisiana to draw a second district where African Americans, who are about 30% of the population, could elect a candidate of choice. They heard that case, pursuant to a challenge under Section 2 of the Voting Rights Act. They did not decide that case. They instead held that case over for this term. And in this iteration in Louisiana versus Calais, they dealt with a different case. The different case was, having drawn the second district pursuant to Section 2, Louisiana was then challenged by white voters who said, we don't think you should have drawn that second district because it offends our understanding of the 14th Amendment and its commitment, according to them, that you should draw districts in a colorblind manner. And in their view, the second district that had a black majority violated that standard. So the Supreme Court hears that case and surprises everybody by raising a question about whether or not Section 2 of the Voting Rights Act was constitutionally on all fours with this Shaw versus Reno standard, this colorblindness standard. And we get a decision 6-3 saying, well, we think it might be, but we're going to reframe how you understand Section 2 of the Voting Rights Act. And with hopefully not too much more time to add, they tried to synthesize a new rule that suggested even when under the act you see evidence that black voters and white voters behave differently, they choose different candidates, that's usually a factor that supports a finding under Section 2 of liability. The court says, we are going to ask an additional question. We want to know whether or not that difference is due not to racial difference, but instead to partisan differences. And if it's partisan differences, the court says we don't want to touch it. And, you know, while one might have taught this, Michelle and Elia, one might have taught this as, well, we're just reframing the law, the court very soon follows up by looking at a case in a concurrent state, Alabama, that had a similar problem. They drew one district instead of two. They get sued under the Voting Rights Act. And the Supreme Court blesses this decision that they were in violation of the act and they should draw two districts. The court comes back to this case and says, you know what? We actually think you don't necessarily need to do that. Even though in Alabama, there was a finding that the state had actually intentionally discriminated. That was different from Louisiana.
Yeah,
and the
it was
court
a
looks
lower
at that
court
and says
decision,
otherwise.
right?
But Michelle, I wanted to ask you, how do you make sense of these cases?
Well, you know, the young folks say today, make it make sense.
Please.
Right. And that's our challenge throughout the last few years with the Supreme Court. So let's understand this not in isolation. One point, I think, which is the last point that you made, where the Supreme Court basically says, if you can justify this by a partisan leaning, then that's okay. Partisanship is okay. Trying to make sure that that black votes are not diluted, not okay when the recognition is based on race. And here too, I think that context really does matter, because we can sort of, you know, beat the carpet and get all of the dust out, but we really have to pay attention to certain priors that are important, which is that in the states that you're talking about a very significant black population, a third of the population in Louisiana, in Alabama, the same. We're talking about the former Confederate states where slavery was robust. And so very large populations of black people who have historically been disenfranchised from voting. Historically so. I am the granddaughter of Mississippi. I was not born there. I was born in the Midwest and grew up in New York, but I did spend tiny bit of my summers in Mississippi as I was growing up, right? So to understand these places and some of the things that black people were put through in order to be able to vote, you show up and you have to guess how many jelly beans in a jar to be able to vote. You show up and you have to guess how many bubbles on a bar of soap in order to be able to vote. You show up and you have to be able to recite verbatim the state's constitution, sometimes to illiterate white people who are the people deciding whether you may vote. We're talking about citizens' councils. We're talking about Fannie Lou Hamer and a group of black women showing up to vote, noting after the murders of Andy Goodman, Mickey Schwerner, and James Chaney, 3 young civil rights activists going to Mississippi to try to register black people to vote. There is sometimes an image that I show my students. It's a note that Andy Goodman sent to his parents saying, I've arrived in Mississippi. People are treating me well. I'm going to be safe. He's murdered. He's murdered. Why? Because they're trying to register black people to vote. And it is this that Fannie Lou Hamer said inspired her, put a burning fire in her gut, that in recognition of those young people and the courage that they had, that she would continue to try to vote. Now, mind you, we already have a 15th Amendment at that time. And we've got dead New Yorkers in Mississippi who are just trying to help this all along. And Fannie Lou Hamer told the Democratic National Convention about what happened to her when she and a group of Black women then further tried this out to go vote. They are dragged off of a bus because the bus takes a bathroom break for them. The police are called because these women just, how dare they, have showed up to try to vote. They're dragged off the bus. They're taken to a police station that housed men. Fannie Lou Hamer remarks about hearing what she called the licks and screams of the other women until the guards called for her. The guards took her out of her cell, put her in with a guy, and a baton was given to this man, and he was told to beat her. And Fannie Lou Hamer describes how she had grown up with polio, and so was trying to protect the leg that had been weakened, disabled by polio. And when the guard was dissatisfied with how she was being beaten, took the baton himself and began beating her in the head. And she tells the country this, not in 1880, 1890, 1910, 1920. She tells the country this in 1964. And she ends it with saying, all of this because we just want to be able to vote.
Yeah. And of course, that point, as poignant as it is still, met with paralysis until 1965. And Congress looks at, as the rest of America does, this awful, vivid footage of people peacefully marching across a bridge, getting attacked by state police officers. And that finally moves Congress to act, right?
Finally does. 1965 Voting Rights Act.
Right.
Which some people might say one of the most important pieces of legislation that we've had, tying to the 15th Amendment, which explicitly mentions race. We understand the importance of voting because it connects to our humanity, to our citizenship, our ability to be able to articulate our own interest. And coming out of that period of slavery, even post-Reconstruction, it becomes critically important because there are any number of laws that emerge in the American South. And Black people are banned from selling rice, banned from selling wheat, banned from engaging in contracts, all of these things that probably are not being taught to a lot of law students who might think, well, what's the big deal? Why can't they just be happy? They got citizenship now. The war is over. But it turns out that there is a lot that's still happening.
Yeah. And we still get, even after 1965, several Congresses that, join in bipartisan, right, majorities that adopt
That was
the
the
act.
beauty of
Yeah.
it. The
And yet-
beauty was that this bipartisan support for Voting Rights Act, and that's the sort of best of our Congress, was to see bipartisan support
Yeah.
for voting rights.
But now we get a court that looks at this and says, well, we're going to take a different view. Elia, I'm interested in your thinking about how this ties in with the amendments, the 14th Amendment and 15th Amendment as well.
Sure. So I'm not usually a moderate. I'm pretty radical on many, many things, but I am sort of a moderate on the Calais decision in that I think it has its good aspects, but also some bad aspects, in particular in the way it was interpreted in the Alabama case, the shadow docket case, which Kareem mentioned. So I'll start with the good and proceed on to the bad. I think the relevant amendment here is actually the 15th Amendment more than the 14th, because of course it's the 15th Amendment which bans racial discrimination in voting. It was enacted because people thought the 14th Amendment didn't cover voting rights and other so-called political rights. With the 14th Amendment, we have an ongoing debate about does it ban all racial discrimination, or maybe it permits affirmative action or some other kinds of things. The 15th Amendment, the text is much clearer. It says the right to vote cannot be abridged on the basis of race, color, or previous condition of servitude. Notice it doesn't make any distinctions based on what is the motive for the abridgment or what group is being helped or harmed, or just a flat prohibition. And on that basis, I think the Calais majority is right about one point, which is that when states deliberately draw majority-minority districts, as was going on in this situation, it is a kind of racial discrimination. It's better intentioned racial discrimination than the kind that Michelle was just talking about, where they thought blacks were inferior and shouldn't be allowed to vote at all, but it's still nonetheless a kind of racial discrimination. On the other hand, there is a flip side, and here we get to the bad. And the bad here is, I think Kareem hinted at this somewhat, if I understood him correctly, but the bad is that obviously when state governments, like in Alabama and Louisiana, gerrymander politically, they will sometimes, perhaps quite often, use race as a proxy for political orientation. I think everyone knows Black voters, particularly in the South, are disproportionately Democrats. You have these Republican-dominated state legislatures. Even if their goal is just, we want to elect as many Republicans as possible and as few Democrats as possible, if they're using race as a proxy to achieve that goal, then that also is racial discrimination. And while the Calais decision isn't completely clear on this, on exactly how to deal with situations like that, it seems possible that they're setting up too high a burden of proof for proving those kinds of cases. And certainly the Alabama decision, which Kareem mentioned, I think it doesn't tell us very much. It's a shadow docket decision without a lot of reasoning, but it does seem like they're raising too high a hurdle because, as Michelle mentioned, the 3-judge district court in that case did find deliberate racial discrimination there, and 2 of those 3 judges on that district court were actually Trump appointees, so you can't easily say, well, it's just Democratic judges who are trying to help the Democrats. That's not what was going on in that case. And so I think the Supreme Court in Calais is right to be suspicious and to crack down on drawing of majority-minority districts, but they may be too soft on the opposite kind of racial discrimination, the racial gerrymandering, where race is used as a proxy for something else. There is one other irony here in that conservatives are very ready, I think often properly, to condemn using race as a proxy when it comes to affirmative action and diversity, but then some of them turn a blind eye here, and also in the case of racial profiling in law enforcement. I think it should not be tolerated in any of those situations, whether it's racial profiling, gerrymandering, or the use of race as a proxy for diversity and other things more in the political left.
Yeah. Appreciate the perspective. And I'll just offer before we go into Arti, we are kind of running close on time, but I will just note, no, that's okay. One of the complications of all this is sort of trying to suss out the difference between partisanship and race. And I often tell people, do you know what the difference is between the partisan motives of George Wallace and the racial motives of George Wallace? Because I don't. And if you can't, you should have a hard time believing Justice Alito that there's a difference. Arti, you had some thoughts about it.
Well, a couple of things. I mean, for the Asian American community, we were never able to really benefit from the provisions of the Voting Rights Act because we weren't big enough. But now we are. And also, what happens, I mean, it's a live question, like when you have multiracial districts, right?
Right, and this court has done a lot to cut that off, but I think that's actually a really interesting and important question that maybe Congress can answer, but we've not been really made able to do it. I'm getting a cue for Q&A, but I'm going to ask this group just a quick hit on one case, and forgive me, Slaughter and Cook was the case that I'd asked Michelle to think about, but I'm just going to start with you, Michelle. Can you teach those two together?
Well, again, we're at the make it make sense. Sort of the through line being that the Supreme Court says, don't mess with the Federal Reserve. We're doing it in quick, right? It's that the president may not arbitrarily remove a sitting commissioner from the Federal Reserve. There are concerns that are raised with regard to economic stability and more to be said about that. And yet we see in the Slaughter case, when it comes to the FTC, back to the questions about the powerful unitary executive and commissioners serving at the behest of the executive and the president having the authority for that removal. Again, looking at the context and backdrop to this, what comes to mind for me is not just sort of these two cases themselves, but the arbitrariness that we seek to avoid when we are paying close attention to the rule of law. And I think that if one were to think about this term and to sum up parts of it, and also the actions of this administration over this past year, has been the way in which the rule of law has come under attack, has become vulnerable, and in many ways a concern about the dismantlement, if we will, of both the administrative state and also a fidelity to the rule of law.
I want to get to some of the questions that our audience has asked. And let me start with the procedural one that has come up in a few conversations points earlier. And I'm going to just leave it open for anyone who's interested. What do you make of the increasing role of the shadow docket? And how do you think it impacts the merits docket? I'll note here that the Brennan Center recently just published work that shows how many more of these big decisions are being decided on the emergency docket.
Well, I want to just start really quickly and just lay something out, which is that this year there were, I believe, 65, 66, maybe 68 written opinions. And if we were to go back 50 years ago, let's just land on 1970 as I was looking at it earlier, 248 fully written opinions by the Supreme Court. So look at that difference, this ability to be able to see where do the justices land? What is the rationale for how the justices have decided a particular opinion? That is very important. It gives guidance to the lower courts. It helps all of us understand a bit better. It helps us as law professors teach our students, be able to say, well, these two align, these two, all of that. And then to see the shrinkage of the work that the Supreme Court is doing, and so that so much of that is now being filtered through the shadow docket, I think is troubling.
Yeah, and to add to your point, it's not just certainly the other courts in the system, but it's legislators. Like in the redistricting cases, they want to know how to draw a line. State legislators, Congress as well, and trying to identify how to frame acts that are going to suffice.
I understand this such that it's not just outcome determinativism, right? And that's the real risk of this court. I mean, I think it's one of the reasons why there is a growing lack of confidence, if you will, in the Supreme Court by the American public, who now say through various polling, we see that there is a lack of trust that they have in the justices.
Artie, you had some thoughts? Yeah.
Well, we had a conversation in the green room about Vasquez Perdomo, which was the Kavanaugh stops case, if you all remember. So he wrote there was no opinion, but he wrote a concurrence with his opinion that it was totally fine to racially discriminate against Latinos. And so, which, if you all have been watching the news, 2 people have been killed, 2 Latino men have been killed in the past week. And this is all part of ICE enforcement. But I do think it's that what that case was from a California decision where, and we are on the ground there, where there was rampant racial profiling happening. You had very strong evidence. You had a whole, like all this trial court information went up to the Supreme Court. They said nothing. They said nothing. And okay, so it was a concurrence. What Kavanaugh said was not what the majority opinion was. But there was no majority opinion. And so the real life consequence of this is that ICE feels emboldened. Now, the Supreme Court did not officially sanction ICE. They didn't say, yes, you can, but they didn't say, no, you can't, right?
Yeah.
And so that's, I think it's very hard as we sit here in Washington, D.C., we're surrounded by buildings that talk about government, that demonstrate government power. I'm in California. I am meeting people in the community on the streets. Those folks don't understand how what the court is doing impacts their daily lives, right? But there is a deep connection, and that is the work that we need to do. We need to connect for the average American. What does this court mean for them?
And a really significant part of that question about building trust. Ilya, about the shadow docket?
So I think there are difficult trade-offs with the shadow docket, and there are obvious problems with it, some of which are illustrated by the Vasquez Perdomo case we just mentioned, in that the court actually wrote no majority opinion at all in that case, simply overturned the injunction by the lower court, but they didn't tell us why. All we have is the opinion by one person, Justice Kavanaugh, explaining his views, but if others in majority agreed with him, they could have joined him, but they didn't, so they offer very little guidance. But worse, when the media covers it, and perhaps the way ICE and others react, think, well, this validates what we've been doing, even though it actually doesn't. It actually simply says nothing about what they've been doing. So that's a problem. And I would note, actually, Kavanaugh himself, to some degree, may have recognized the problem, because later in another shadow docket decision, the Illinois v. Trump, which is the National Guard case, he wrote another concurring opinion. In a footnote, he said, well, actually, race can't be used in immigration stops, which seems very different in Fisher and Vasquez-Perdomo, where he says it can be used so long as it's just one of several factors, right? So that, I don't know about you, but that seemed to me inconsistent. On the other hand, I do think there are sometimes situations where it's desirable to use the shadow docket, in particular when there is an ongoing abuse of power or legal action that needs to be put an end to quickly. I think the National Guard case actually illustrates this. The court rightly said that Trump was using the National Guard illegally, though I don't fully agree with some of the reasoning. I think there's other reason it might have been better. And that really did put an end, at least for a time, to Trump's efforts to federalize the National Guard, and that was a good thing. So I would hope that they would use the shadow docket more sparingly, and when they do use it, I would hope that they would give at least some significant explanation of what they're doing, as they did in the National Guard case, whereas in Vasquez-Perdomo and in some other cases, they tell us little or nothing. And I know they're working under time pressure, but we paid them the big bucks to give explanations of their decisions. And so in that case, that at the very least should not have left to just one justice to say something. The majority should have said something more clear and authoritative.
Okay. So another question from the audience, I'm sure akin to our work on state courts. Here's a question. How do state courts fit into the equation when SCOTUS cuts back on our rights? Any takers? Ilya? Yeah, sure.
Fools rush in where wise men fear to tread. So I think obviously each state has its own constitution. And as I and other scholars have written, sometimes they interpret those constitutional rights more broadly than similarly worded provisions in the federal constitution. And there are also some rights that exist in some state constitutions that don't exist in the federal constitution at all. And I think often it's good if states protect various rights more than the Supreme Court's interpretation of federal constitution does. But there is this limitation, which is that they can only protect you in most cases against actions by the state government. State constitutions don't bind the federal government, with rare exceptions we can talk about. So, for instance, there's only so much that states can do about the abuses of ICE, though they can enact sanctuary laws, and those are actually interestingly protected by the federal Supreme Court's precedent set up by conservative justices. But what that does is it can prevent states and local governments from cooperating with the federal abuses, but usually it cannot prevent those abuses completely. So there's a lot of value to state constitutional protections for rights, but they do have their limitations as well.
So Michelle,
Yes, just two quick thoughts. One is about paying attention to the money that is coming into state Supreme Court elections, which is something that we don't pay enough attention to, write enough about. Ilya, you may be writing about this, but I think that there's far more scholarship to do on this. And then also thinking about the Dobbs decision. We're in the 4th year anniversary of the Supreme Court overturning Roe v. Wade and Planned Parenthood v. Casey, and the Supreme Court saying, well, just vote it out. And we've just talked about Calais and what that means. I found that really, really quickly to be ironic, considering that that case came out of Mississippi, where voting rights have been very fraught for Black people, and the people most vulnerable to that decision would be Black women, now in a state where it's very difficult to vote, and the court saying, well, we'll just leave this to the democratic process. If you don't like it.
Not a great social scientist.
Yeah, totally not. And so what does it mean then when we're looking at what many would see as fundamental rights, very important rights that people have, and those rights being vetted before courts, state courts, where there may be conservative majorities, and it really shouldn't matter, conservative, liberal, et cetera, but where there are rights that should, in fact, be not tampered, if you will, by whatever the makeup of the court happens to be. But I would certainly say within the context of reproductive freedoms, we've seen a lot of vulnerability there, particularly when we're talking about courts upholding states' laws, and states' laws now, post the Dobbs decision, being just so absolutely heartbreaking, I think, is one of the ways to think about it. And give Texas as just one example post Dobbs, where the risk for a doctor performing an abortion is losing the license to practice, risking 99 years incarceration or $100,000 fine. So follow the law. You have a doctor that breaks it, here is the law. Louisiana, where there have been doctors that have testified before the House, there it is, I have an 8-year-old patient who is pregnant. Your law that bans abortion, including in cases of rape and incest, would make this 8-year-old have to become a mother. What does that mean before courts upholding those laws?
We've got a great group of folks at Brennan who are looking closely at state courts and constitutions, who are examining all of that, including the fight to structure or restructure state Supreme Courts. Arthur, you had some thoughts to add to this?
I was just going to say, this is the challenge. Now like in California, what we're doing is we're crafting a California, improving our Voting Rights Act. Yeah. Basically. So it's not just state courts, it's state legislatures, right? So, and we're using our police powers for that. And the same, we've put all kinds of protections in on sanctuary, and that was based on the 10th Amendment. So I have to say, when I went to law school, states' rights was like the purview of the right wing. And now those of us who are in blue states are embracing states' rights. And so part of it is, what do we need to do to protect our people, right? That's the issue. But the real failing here is that we need Congress to ultimately fix some of these deep societal challenges, right?
I take the point, and I'm getting the rap signal from our folks, but I'll say that's a great point to end on. It reminded me of something I've been thinking about with respect to this question: what can we do? Because that's the most common question after hearing all the things that the Supreme Court, or frankly any institution, is doing. And I'm reminded of a statement that came from Abraham Lincoln. He wrote, "We the people are the rightful masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who pervert the Constitution." Obviously, this is an election year. That is a part of the analysis that we'd encourage people to use as they participate in the election process. But for now, I want to thank each of our wonderful panelists who have made this discussion fun and robust. Thank you. Oh, please. And now we'll turn it over to Stephen, who will give us directions on the next thing.
Thank you so much. I think we could have had an entire hour on one of the cases, and that was just fabulous. So thank you so much. We're going to roll into our second panel now, Congress and the Courts, moderated by Alicia Bannon, who is the director of the Brennan Center's Judiciary Program. I will note that following the panel, we do anticipate Senator Whitehouse will probably go right into his keynote address, but we will keep you posted, and I will continue to be your MC in that regard. But we're really looking forward to this conversation now about Congress and the courts. And just a reminder, there will be a number to text any questions for the moderated Q&A. And with that, I'll turn it over to Alicia Bannon.
Wonderful. Thank you, Steve, and thank you all of you for being here, and those on the live stream as well. In our previous panel, we concluded with this question, what can we do? And that's exactly the topic that we're going to cover in our panel. I'm really excited to be moderating this conversation about Congress and the Supreme Court. The Supreme Court's structure and design is often treated as a fixed feature in our system, and that's not true as a matter of the Constitution as well as our history. And we're going to talk about the significant role that Congress plays in regulating the Supreme Court. We have a wonderful panel to help us think through these questions. At the far end, we have Don Ayer, a retired partner from Jones Day, who also serves as an adjunct professor of law at Georgetown University Law Center. He spent 10 years in the Department of Justice, including serving as Deputy Attorney General during the H.W. Bush administration. He's argued 19 times before the U.S. Supreme Court and clerked for Justice Rehnquist, so has lots of different kinds of experience with respect to the Supreme Court. Next, we have Daphna Renan, the Peter B. Monroe and Mary J. Monroe Professor of Law at Harvard Law School. Her current work analyzes the rise of judicial supremacy and its implications for democracy. And she is a co-author, along with Nico Bowie, on a forthcoming book, Supremacy: How Rule by the Court Replaced Government by the People. So get your pre-orders in. She also previously served in the Department of Justice and the Office of Legal Counsel and is a law clerk to Justice Ginsburg. Finally, we have Damon Hewitt, the president and executive director of the Lawyers Committee for Civil Rights Under Law, one of the country's leading civil rights organizations. He has more than 20 years of civil rights litigation and policy experience, including prior leadership roles in the nonprofit, philanthropic, and public sectors. So we have a wonderful panel here to discuss. I'm going to pose the first question to each of you. How is the court, what is your assessment of how the court is performing right now as an institution? What's your take on its recent record? And what is the role you think it should be playing in our constitutional system? Damon, can you kick us off?
Sure. I was speaking to one of your colleagues at the Brennan Center a little while ago, and he asked, is the court fulfilling its role? And my response was essentially, if the court understands the assignment, it's not the assignment from the Constitution. It's maybe what someone once called a domestic political errand or something of that sort. What I think people are seeing and feeling is a degree of certainly inconsistency in terms of how jurisprudence is applied, kind of selectively narrow or selectively broad, just depending on the context, seemingly to get to a certain result. We're seeing what people view as I think it is, but many people think it's a lack of intellectual honesty, maybe an intellectual dishonesty. So that's not really fulfilling the Article 3 role. But also, it's just things that people simply can't wrap their minds around. Why are things changing so rapidly, so quickly after many decades of jurisprudence? Most people in the country don't know what stare decisis means, if you're not a lawyer, but people actually expect a degree of stability. And so it's a lot for me to say as a change in cause civil rights racial justice lawyer that I actually favor a degree of stability, because we're often trying to change things in systems. But the truth is, no one wants herky-jerkiness from a Supreme Court, because systems convulse, communities convulse, nations convulse if you don't have something that you can actually count on to some degree. So in that regard, I don't believe that the court is playing its role very well. One other dimension I'll say, Article 3 essentially tells us, uses the word controversies multiple times. Courts, especially the Supreme Court, is there to resolve actual controversies, disputes presented thereto, not broad, generic issues. I think we get at least borderline, but a lot of feel that there are issues that are being decided. Issues not even presented before the court. We at the Lawyers Committee spent a lot of time working on redistricting cases. We won 2 big redistricting cases. The Texas case that started it all. We were part of the legal team that won the trial before a 3-judge panel, and a Trump-appointed judge wrote the majority opinion saying this is racial gerrymandering. The day before the big Louisiana v. Calais decision that everyone's been talking about, the Supreme Court vacated and remanded that Texas victory with a one-line order. The lack of reason, the lack of articulation and explanation, the lack of fulsomeness. When you see dissenting opinions that are much longer than majority opinions, that's not always a sign that the majority is at fault, but we're seeing the explaining isn't coming from the majority. The explaining is coming from dissents, because people need to try to figure out how to make sense of what they're seeing. So those are all the reasons why I feel that this court, as currently comprised, is certainly not playing the role as intended in the Constitution.
Daphna.
Yeah, absolutely. I agree that there's a difference between the exercise of raw power, which is what we're seeing in a lot of these opinions, and the reason giving that we typically associate with the role of the judiciary. And there's another really important distinction, two different kinds of power that we've seen play out in the past term and over American history. And one is a court that enforces duly enacted federal statutes against anyone that would violate them, whether that's an ICE agent or a state or the President of the United States. And when the court plays that role, it's a really important role in our constitutional system. And we see that this term when the court tells the president your sweeping tariffs violate the Economic Powers Act, or your deployment of the National Guard violates federal statutes. Your interference with the Fed is unlawful. But there's a different and much more pernicious power that we're also seeing this court take on with tremendous vigor, and that's the power to reject or defy enacted federal statutes. So in the Slaughter case from this term, the court says, yeah, we have a 100-year-old statute that protects the president from being able to remove civil servants and putting in his bootlickers. Well, we're just going to shred that statute. It doesn't apply anymore. Or we have a Voting Rights Act. We have a Voting Rights Act that generations marched and died for, that hundreds of members of Congress multiple times enacted into law, multiple presidents signed. A generation fought to put an understanding of the 15th Amendment and what it stood for into a federal statute. And a court just says, you know what, we'd rather the 15th Amendment read differently. We'd rather the 15th Amendment stand for something else. And so we can no longer have the Voting Rights Act play the role that it's played. And it's not just the Voting Rights Act. The court has basically put a bullseye around disparate impact statutes or federal statutes that say the effects, the discriminatory effects, can be prohibited by federal law. So cases like that, cases like the Calais decision and the Slaughter decision, unfortunately follow a very long line of cases where the court has said, we have the power to reject, we have the power to defy enacted federal law. The first time the court did that was Dred Scott versus Sanford, an 1857 case where the court said, we think statutes like the Missouri Compromise are unconstitutional because they don't adequately protect the rights of enslavers. And it wasn't just Dred Scott. Dred Scott unleashed a power that then we see the court reacting to Reconstruction and invalidating the first civil rights and voting rights laws enacted by Congress. We see the court using this power to invalidate child labor protections, workers' rights protections, protections for agrarian work, protections against corruption. And that's the power that the court is exercising in a case like Calais. There's a different kind of constitutionalism, a way to understand the court's power as enforcing, not defying federal law. And anti-slavery abolitionists, Reconstruction Republicans, progressives, and early civil rights pioneers argued for that more democratic vision of the Constitution. And it's one that we can demand our members of Congress to enact into statutory law today.
Thank you. We're going to hear more about that history. Don.
Yeah, I agree with the sentiments they both expressed, and I would add a little bit different historical perspective. I've sort of been following the court since I was principal deputy SG back in the 80s. That was under Ronald Reagan. And what you've seen over most of that time is a generally what you would, in today's terms, call a conservative trend on the court, where over time, decisions in various areas, now and then there would be one that one would characterize as conservative. And the trend over time in general was in that direction. And the thing that's happened, and all of that was within the framework of justices who were not all appointed either at the same time or out of the same school of thought, who would get together or not get together on a certain way of reasoning through a problem. And so every term, it would be a question of how would cases turn out, and the mixes that you'd get were, even on the most important cases, somewhat unpredictable. Well, what's happened in the last 6 years is that you've got, as we all know from watching the appointment processes of the 3 Trump justices, we have a group of people. They don't all agree on everything. That's one thing you can all agree upon, but they agree on an awful lot. And they have what one can think of most of the time as a supermajority on a given issue. And that's true on many of the issues that are what we think of as hot button issues, big issues, major questions about how the government's going to function, how rights are going to be recognized or not recognized. And so we've seen, as you've all lived through, we've seen a deluge of decisions making radical changes. And that's a real problem for the way citizens receive the work of the courts and the Supreme Court. We think of law as being something that has stability to it, not that it's cast in stone, not that it can't evolve, not that it doesn't change, but hopefully change somewhat gradually and hopefully with a sensitivity about what went before. And we've seen so many radical changes. And just to tick off the areas, one having clearly to do, as we've seen, with the administrative state and the ability of agencies that we've created over 100 years, really, to address what we thought of when we created them as modern problems that needed a special handling. And many of those were put into, especially in the 30s and later, agencies that had independent selection processes and some effort to have continuity. The whole situation of race in this country, we've talked about the Voting Rights Act being gutted. That's only a piece of it. That's true, and that's happened, and it's terrible. And most of it happened very recently. It started out with Shelby County. I think it started out with Shelby County in 2012. But it's come along, and most recently we've seen these radical changes. You heard about Calais and then the retake on Allen v. Wright and this sort of irregular stuff that the court does just to turn a whole situation around in a radical way. Well, we've also, as you all will remember, decided that race, even though the 14th Amendment was designed and intended to somehow address the problem created by 250 years of slavery, essentially the Supreme Court has returned the whole question of the 14th Amendment, I think it's fair to say the whole question, back to sort of neutral, back to, well, no discrimination as to race, period. No consideration of affirmative reasons to consider race. Voting Rights Act had this interpretation based on Congress's enactment as to how it should be interpreted with regard to districting. Bingo, that's gone. Our whole set of changes with regard to the Second Amendment, in 2008, the court suddenly, after many, many decades, recognizes a personal Second Amendment right, and that's gone on, and now we're stuck with reading the Second Amendment with regard to analogs of history rather than any sensible approach of asking how the protection should be read in the face of our modern situation. The last thing I'll just say, and this would require a much longer discussion, which I will forego, but there's lots of things about what the court's done lately that just don't wash, that you can't find support for, and they seem to have been done just because they wanted to, for some reason. And the best one that is most familiar is the immunity case. Where in the world did the idea come from that the President of the United States is immune from crimes that he commits as President of the United States in a role, that everyone had always assumed you could be prosecuted later for? But there are lots of others. There are many instances that I won't bore you with where the court is getting to a conclusion, it just rolls over something that it said before, often without even acknowledging it. And the court's not functioning as a as an institution that views itself as accountable on a rational basis for the things it does.
Thank you. Damon, you wanted to jump
We
in.
just do snaps for their comments. Like, it's just
Welcome in.
deeply insightful. There's a word that I'm not sure any of us use, but it's a through line. It's legitimacy. At one of the closed-door Kohlberg sessions, which I won't say everything we discussed there, I think it's Chatham House rules, but the question of legitimacy came up, and one of the offerings I suggested then was like legitimacy works in like a couple of lanes. Like there's constitutional scholars and practitioners, people like us, but then there's just like regular folks. We reject, as you can see, some of what we're seeing, but regular folks definitely reject it. Dred Scott, the case that Daphne mentioned that kind of was a Pandora's box in terms of jurisprudence, is also the case that told us that the Negro has no rights which the white man is bound to respect. I'm pretty sure black people at the time, the abolitionists, rejected that notion, and people of conscience rejected that notion. Just like people reject, you have no right to stop a state from telling you what you can and cannot do with your body. People just viscerally reject that. Some of the through line in the voting rights jurisprudence is, well, things are so much better now. There's really not racism in voting and discrimination in voting like we used to see. Or like in the another case we litigated, litigated for 9 years the Harvard and UNC cases and argued in the Supreme Court alongside Harvard's counsel and UNC's counsel, the SG there, and the SG of the United States, Elizabeth at the time. And, the whole reasoning and logic was based upon this fixed notion of colorblindness that doesn't respect, as you said, actual historical context and contemporary context. People viscerally reject all of that because it does not rhyme with their lived experience. And so this is what prompts the crisis of legitimacy. It's not just debates about what the law should be. It's basically the court is devoid of actual human reality, at least in this country.
Thank you for that. Daphne, let's talk about Congress's role in all of this. And in particular, in your upcoming book, you argue that Congress used to be much more in conversation, in dialogue with the court. So can you talk to us a little bit about Congress's historic role, how that changed and why that changed?
Yeah, great. So the question of Congress's role vis-a-vis the Supreme Court is one that is crucial not just for our generation, but has been across American history. And when people viscerally disagreed with Dred Scott, they didn't say, well, the court has the final say on that issue. They formed a political party, and they understood, the founders of the Republican Party and their abolitionist allies understood Congress to have a responsibility, as they put it, a solemn duty of Congress when it understands the Supreme Court to take positions that defy rights and liberties that don't resonate with our lived experience of what the Constitution should mean. The Congress should enact statutes that take a different position and that prevent the Supreme Court from interfering with those understandings of what the Constitution should mean in American life. So the Reconstruction Congress passed statutes limiting the spread of slavery in the territory, notwithstanding what Dred Scott had said, stripped the court of jurisdiction to decide the constitutionality of its really consequential Reconstruction acts, and debated additional measures, including the author of the 14th Amendment, the primary author of the 14th Amendment, said, we should have a rule that prevents the Supreme Court from invalidating any act of Congress if there's not at least a supermajority on the Supreme Court that believes that that act of Congress is unconstitutional. The primary author of the 13th Amendment said, actually, I want to go further, and I'd like to see us Congress say there are certain issues that are political questions that the court shouldn't get to decide, that they are decided and resolved through our politics, and we, Congress, should assert that power. And even as Congress is very ambitious in its understanding of its role in preventing the court from interfering with what are fundamental commitments enacted into federal law, the court is also enlisting the federal courts to enforce federal law and to enforce federal law against the states, at the time against the former Confederacy. So Congress passes the 1871 Klan Act, which a remnant of it is what we today describe as Section 1983 because of where it exists in the U.S. Code today. And Section 1983 that derives from this Reconstruction statute is the root of cases like Brown versus Board of Education, where what happens is Congress, by legislation, says, courts, we need you to help us enforce equal protection against the states, and courts participate in that project. That Professor Bowie and I in our book describe as vertical review, or the power of the court to supervise the states. And it's crucially different from horizontal review, or this idea that the court gets to reject acts of Congress. And this distinction between horizontal and vertical review used to be quite central to how Congress thought about what kind of power it was giving the court and what kind of power it was preventing the court from exercising too robustly. And we need to put that distinction back into the conversation today.
Thank you. I'm going to turn, Don, to you next to talk about one specific Supreme Court reform that has gotten some attention recently. You wrote compellingly in a recent piece for the Society of the Rule of Law about Supreme Court term limits. And in particular, you mentioned clerking for Justice Rehnquist and how he thought 15 years was enough. Can you talk a little bit more about term limits and how you think this reform would make a difference?
Yeah, I at the same time, I'm very distressed about what the court has done substantively. It's a huge problem. We have another problem that's more fundamental, and that is trust in the court, which of course is not unrelated to the things the court's done. It's also related to ethics issues. It's also related to some rather unusual nomination processes. But now that we're where we are, the question is, what can we do to make things better? But make things better meaning we need a Supreme Court that can function. And one of the things that I think is not a good idea, which I think there is some support for, but maybe not that much, I hope, at this point, would be just the idea of stacking the court, of packing the court, of saying, look, we don't like your decisions, so we're going to add enough people to get them changed and get what we want in a court. Obviously, the lack of trust in the court, which is the product of a lot of things, won't be aided by that. What that would do would be to secure a public assurance that, yes, the court is just politicians in robes. It's just political. It's not really about law. It would undermine the fundamental idea of the rule of law. On the other hand, term limits, if you stop and you think about it, which many have, and the fact that many have means and has resulted in overwhelming support publicly, it's pretty much nothing but a good idea. It's something that I would think the founding fathers would wish they'd thought of. If they had thought of it, because what it is a much more sensible system. As a law clerk, I did have a conversation with Rehnquist. I couldn't tell you when it was, but I just remember him saying, and he certainly wasn't talking about term limits. He was just saying, 15 years is long enough for anybody to serve on the Supreme Court. And I don't remember the context, and I don't remember why, but of course, it's illustrative and significant that in his instance, things look different when you're 80 years old than when you're, I think he must have been 45-ish or 50-ish or thereabouts, because he ended up serving 15 years as a associate justice and another 18, I think, as the Chief Justice before dying in office of cancer. He did not want to leave, and yet he saw the wisdom in that. So the thing about the term limits is, number one, there really isn't a very compelling idea for very, very long service in a democracy in a very significant role that you've not been elected to serve. There's an unevenness and a tension with the idea of democracy of having people in black robes. And the way to, of course, you need it because you don't want them to be political, but a very sensible way to ameliorate that issue is the way most court systems have done it. And that is they have a set term or they have a retirement age. And it's just an obvious and a sensible thing to do. So from that point of view, from the standpoint of democracy, it makes an enormous amount of sense. It also makes a lot of sense from the standpoint of the succession process. Different approaches vary a little bit, but the main idea with if an 18-year term is the right approach, which is somewhat debated, but I don't think that much, then what you would want to have is probably each president at the beginning of near the beginning of his first term, and then after 2 years would get one nomination, and that would then go through the system on a routine basis. There'd be a proportionality, a rough proportionality between chances to nominate and the party of the president who got elected, unlike the justice himself or herself. It hopefully would contribute to reducing the strangeness of some selection of some nomination processes. You can't be sure because misbehavior is possible at any time and you can't rule it out. But just the idea that this is a scheduled event as opposed to an opportunity that crops up when Justice Scalia dies and the Senate decides to hold its breath for 9 months in order to put in a Trump appointee, or to the contrary, Ginsburg dies in what I think was September of 2020, and by golly, nothing will do but to race through another nomination before the new president takes over. So it's a situation that I think has very little of a downside. The other thing I will say is that the popularity, I'll put it this way, of octogenarian public officials is not at a peak in this country right now. And I think there's good reason for that. It isn't just octogenarians, but it's people who are well along in life, as to whom there may be reasons that are good or not so good. But even if they're not so good, they'll still be there to speculate about whether they're up to the job. Well, why not deal with that by a plan that, at least on average, says appoint someone, they'll be there 15 years. If you appoint them at 55, they'll leave at 70. If you appoint them at 50, they'll leave at 65. They won't be 85 or 87 or anything else. And I think, there are cases where that has mattered. One, which I was not present as a law clerk for, but I remember the residue of it the next year when I was there, Justice Douglas. Justice Douglas had a stroke in 1974, I think it was, and was incapacitated in a major way. And the other members of the court, really tried to persuade him to leave. They finally succeeded, but he refused for a very long time. And before they succeeded, they actually had set up some system on the court to make sure that he would not meaningfully participate in any cases. That is to say that he would not affect the outcome of any cases. Well, that was not a handy situation to have to deal with. And frankly, nor was the situation with Justice Ginsburg. When she'd had for 11 years, she'd had cancer and at 87 died at what turned out to be a very inopportune time, which frankly has led to the current situation we have with the court. Rehnquist himself died under strange circumstances where he had, I believe it's true, ended up sort of negotiating with Justice O'Connor. They'd agreed one of the two of them should leave before the end of the first term. I think it was the first term of President Bush. And apparently I've been told on not such good authority that he urged her to leave. And he then promptly died. And O'Connor then went on for a number of years sitting on courts of appeals and various other things. So anyway, this is not a situation we ought to want to see. And the question arises, well, what's the downside? And frankly, why haven't we done it already? And I don't know a good reason why we haven't done it already, because it's just our dysfunctional, I think, political system. Because the only things I hear and the only things I saw in the work of the Presidential Commission on reforming the Supreme Court was a lot of things about, well, how would it work? Well, what would the term be? Well, how are you going to, what are you going to do about the fact that these justices are here? There are a lot of things to work out as details, but they're details and they ought to be worked out. And we should get on with the task of doing this because it would be a great improvement in the functioning of the Supreme Court.
Thank you for that. And we're going to make sure we leave some time for audience questions, but I want to hear from Damon and then the rest of you. So, I mean, Damon, you raised some very kind of profound critiques of the Supreme Court. Can you share with us both the Lawyers Committee's current thinking, right, about Supreme Court reform, but then also how do we get there? I think one of the biggest challenges or concerns that people raise when we talk about Supreme Court reform is just a sense that it's not possible. How do we make it possible?
Well, I want to first acknowledge my colleagues, Mark Villarica and Chanel Sherrod, who are here in the audience, who helped frame some of my thinking for this discussion. I will also acknowledge that I was quite surprised that you all asked me to be on this panel, because we at the Lawyers Committee haven't been leading the way on new ideas. I have ideas, which I will share.
Welcome all ideas.
So I'm speaking maybe a little bit more, blame me. If you like it, give them credit. If you don't like it, blame me, right? That's how it works. So when we submitted our comments to the Biden Commission, we had, the 18-year term limits. The whole universe landed on 18 years for mathematical and other reasons, and also a Biden Code of Ethics, which I really want to lift up here. And those are things Congress can do. So if I understand the question correctly, what can be done? How do we get there? I want to first just credit Brennan Center. You all had a short piece that just made clear that there's lots of things that Congress can do within the bounds of Article 3. And I completely agree with that. Term limits do not require amending the Constitution. That's a Judiciary Act type of enactment. But what I would say is, here's where we are, where I think we are in the civil rights community and at our organization. What we agreed to several years ago with the Biden Commission, what seemed fine then is probably insufficient now, because we all now have more battle scars than we did before. We've seen how this works in practice. And the composition of the court has not changed radically in terms of like the numbers, like the seats, right? But what has changed is the jurisprudence and the lack of temperament, the lack of kind of limiting principle, so to speak. And so what got us here won't get us there. So I have, and I know a lot of us in the civil rights community, as we win cases below, only to have their victories erased in the Supreme Court, we're hungry for more, which is part of why, a lot of us are here today and a lot of us are in these conversations committed to being in dialogue with Brennan and other colleagues. How do we get there? I think it starts with Congress. It starts with a Congress that has a spine to actually propose and enact legislation. I know I always say with Senator Whitehouse, he's got a bill for that. Whatever it is on Supreme Court reform, he's got something for that. And there could be other ideas as well, even from other sources. But it takes a Congress that has a spine to actually use its own authority under Article 2. It also will take a president to enact the legislation. I actually think about Supreme Court reform in some ways similar to the way I think about redistricting. It actually takes, because we believe that partisan redistricting needs to end. I get to fight fire with fire, but it does not end well, certainly not for Black voters or other voters of color. But what I would say is to radically transform redistricting would actually take a group, a party that has political power to essentially cede or share that power. And I think of that parallel when it comes to Supreme Court reform. It's actually going to take a party that is actually already getting its way and has all the authority to actually say, you know what, this isn't working for the country, this isn't working for everyone. Now, maybe the balance shifts, and I think that I like to think that we could get to the 2006 reauthorization of the Voting Rights Act was 98-0 in the Senate, right? like to get to something like that on Supreme Court reform and voting rights again. But here's the truth. The margins are really slim, right? The margins are really slim, and political reality could change within a matter of years to actually get legislation passed in one chamber, and then maybe another chamber, and maybe by the White House as well. So I do think it's going to take congressional enactment. And as Congress is central, because Congress has capitulated, Congress has lost its spine, and the Supreme Court has frankly just run roughshod and rogue over anyone it wants to. It has enabled this president, but it tried to cripple President Obama and his executive actions, right? A different constituted court, right? But the point being, I think Congress is central to restore balance. And that's important because that's where we, as the people, have a lot of the say in the power. We elect these people. We have to hold them accountable to doing things that actually, as I said earlier, rhyme with our lived experience.
And Daphne, Don, do you have anything you'd like to add on how do we actually make reform happen?
Yeah, so the court has the power that we decide it has. The idea that the court gets to strike down federal statutes is not stated in the Constitution. We, the people, accept that power, or we demand that our members of Congress enact legislation that regulates that power. And the Congress has regulated the Supreme Court across history in lots of different ways. It stripped the court's jurisdiction to decide the significant Reconstruction Act's constitutionality. It channeled jurisdiction to decide certain cases to certain courts in certain contexts. It decided what kind of remedies are available, for example, with respect to strikes and labor or tax, eliminating injunctive relief in some of those contexts. It changed the functions of sitting justices, telling them to ride circuit or to not ride circuit. So Congress has both the constitutional authority and the constitutional responsibility to regulate the court. And I think what we, the people, need to demand is a Congress that does this in a way that allows Congress to make the substantive commitments, whether it's a new Voting Rights Act, whether it's reproductive rights, whether it's environmental law, to pass that legislation and then ensure that the court doesn't stand in the way of those reforms being allowed to take effect. And I think one of the strongest ideas out there that have been proposed across history is for something like a consensus rule. So Congress passes a law that says, court, you don't get to invalidate an act of Congress unless something like 2/3 or 3/4, even a unanimous court says, yes, there's really no plausible way to see that as consistent with the Constitution. That's a very old idea. Some people associate it with a scholar from the 19th century called James Bradley Thayer that said, look, there really needs to be an obvious, clear error before the court can put aside a federal statute. There's a way to turn that idea, which for a long time the court itself said was at the foundation of judicial review. There's a way to turn that idea into a rule that says, actually, if a couple of justices on the court think this is a constitutional statute, and hundreds of members of Congress, either with the president or in numbers that could overwhelm a presidential veto, have said this is a constitutional statute, then a mere one-person majority on the Supreme Court shouldn't get to invalidate that law. So these ideas are out there. They've been proposed across history, and it's time that we demand of Congress. I agree fully with Damon. It starts with Congress to put that into federal law.
Don.
I guess what I would say, I totally agree that it's going to take the people not only voting in response to a poll that they want some of these things to happen, but also being more affirmative in such a way that they, elect a Congress and a Senate that will want to do some of these things and then have a level of public enthusiasm that will support it. I also will just add that I really, as distressed as I am about the Supreme Court, and I'm very, very distressed at where they've gone, I think we got to be really careful about what sorts of changes we make. In other words, they need to be changes, I think, they need to be changes that are a good idea on their own and don't sound like we got the votes, so we're going to do it to you. And that's a tricky thing, and that's a hard line to draw. And I don't think it's clear where that line is. But I think we better be darn careful, or we are going to end up, because we're real close to it right now, we're going to end up with a court system that nobody trusts because they're convinced, sadly, maybe rightly, that it's basically a political instrument that those in power can use the way they want to use it.
Thank you. I'm going to turn to some audience questions. Welcome anybody who'd like to jump in. The first is about the Calais decision, which we spoke about in the previous panel. Can you tell us about the need? What does that decision and other democracy misshaping decisions like Citizens United or Rucho tell us about the need for Congress to reassert its role as the primary federal policymaking body through checks on and reforms of the court? Anyone like to take that?
Well, Calais is like the Plessy v. Ferguson of voting rights, in the sense that it is like bad, bad, bad. It's a sea change, but also it's a constitutional dimension in terms of like the ruling. So a new statute can't fix that, but it can certainly put some salve on the wounds. Eventually, you need a new court or a new constitutional provision to interpret this very differently. So I think that's my starting point. But I do think when you think about what was like, it felt like a slow burn, but it was really short in a span of time in terms of like Shelby County, 2013, Rucho in 2019, Brnovich in 2021, and now Calais. All those other decisions could have been addressed squarely through legislation. They may have actually, if not stopped, slowed down what eventually happened. You know, the same theory in Calais was laughed out of court in the Milligan case, the Alabama case, just a few years earlier. Chief Justice Roberts saying, "Do you saying you have to allege and prove intent?" Oh no, when I say like, but that's now been mainstreamed, right? As a theory, and so the failure of Congress to act all throughout that time has led to kind of compoundingly bad results.
So I just want to offer that I think if we change the kind of power that the court has over constitutional interpretation, then we also respond to Calais. So if Congress enacts a statute that says you need a 7-2 court before it can set aside an act of Congress, then we can't set aside Calais on these thin votes that we're seeing. And I think it's time that we demand of members of Congress that kind of check on the court, that kind of regulating the court, to ensure that if the court's going to set aside an act of Congress that over generations, thousands of members of Congress, multiple presidents have thought is an important understanding of the Constitution, that there, at a minimum, is a deep consensus on the court that there really isn't an available constitutional defense of that statute. That's not the rule today that governs the court, and that's part of how we get decisions like Shelby County and Calais.
So another question from the audience. We heard about the court operating without accountability and concerns about the court's legitimacy. What can Congress do to infuse the court with more accountability and legitimacy?
Say that again.
What can Congress do to infuse the court with more accountability and legitimacy?
Well, I think one thing that isn't directly related to its decisions is I think Congress should somehow enact a law that requires enforceable equity, ethics rules on the Supreme Court. I think one of the most appalling self-inflicted wounds by the Supreme Court is its inability to figure out how to have independent enforcement of the ethics rules. They propounded a bunch of rules a couple years ago, and but they're not enforceable. We just enforce them ourselves because we're justices and we can do that. Well, that's insane. And there's no reason that they shouldn't be treated like everybody else. And the very fact that they don't realize that indicate that's the problem right there. So that's one thing that Congress could do with regard to accountability. I really do think, I mean, I do agree with Daphne that there are a lot of things that Congress can and should do to assert itself about what the law should be. And this is probably not the place, at least I'm not equipped, I'll put it that way, to go through and give you 4 or 5 examples of what that is. But I think Congress has every right in the world to be to be asserting its own views and in the form of laws and rules about what ought to happen. I'm not as excited personally, and I may be completely wrong and just an old softy, but I'm not excited so much about telling the court it can't decide certain things. Or the one that I'm really not excited about is something that in the early days, but I guess yet again, they called departmentalism, which was the idea, and I guess still is the idea, that's somewhat been revived. Well, actually, no, the court doesn't decide what the law is. Everybody gets to decide what the law is. Congress gets to decide, and the president gets to decide, and good luck with all of that. And it will, may the best person win. I kind of bought the idea that Marbury v. Madison said it's the court's role to say what the law is. Now, if we had a better court, I'd feel better about that. But a system where you have a Supreme Court that says what the law is, I kind of grew up thinking that. So I'm not entirely ready to walk away from it. Now, I realize we're not in a great spot right now because we don't like what the court's saying the law is, but I'm troubled by the idea that, I'm certainly troubled by the idea that Donald Trump gets to say what the law is. And that's certainly his claim as well. So I don't know. There's a lot of room for discussion of that subject, and it's not a simple subject.
I've agreed with almost everything you said. There's one thing I'll not even a pushback, maybe a friendly tweak about Congress kind of limiting what the court can review. The court limited itself in Common Cause v. Rucco, saying that political gerrymandering is non-justiciable. The court selectively does that to itself. So that, to me, opens up the door to maybe the court shouldn't be the only arbiter of what's a political question or what's beyond the reach of the court. So I don't know if you ever thought about that.
Well, on that question, I totally agree with you. And I guess I don't know what effect it would have, but the idea that the Supreme Court doesn't have a role to play in what I always would have thought, had they not written that out of the Constitution, was ensuring a Republican form of government for everybody. The idea that they refused basically to play any part in stopping political gerrymandering was really a bad thing. And I would think Congress could speak out on a variety of issues like that. And whether the court will buy it, I don't know. And how to do it best, I don't know either. But I surely think that's right. And those are the substantive ways of the Congress, I think, speaking up are really, really important.
Great. We're going to be wrapping in a moment, but I'll welcome Daphne to respond.
Yeah, I just want to say, I think that Congress has the authority and the responsibility to make sure that what the court does is enforce federal statutes against everyone, including the president, including executive officers. And one thing that we've seen is when the court claims that it gets to say some federal statutes don't need to be obeyed by the court, it's also emboldened the presidency. So you have a president that says, I don't need to comply with these restrictions on my power because the court has said we don't need to do that under Article 2. And so a system where what you have is a court enforcing federal statutes is also a system that allows federal statutes to hold the president to legal account.
Thank you. And I think this is a very deep set of questions about the role of the court as well as the role of our political institutions. This has been a wonderful conversation. I wish we had more time, but I'm getting the wrap signal. So I just want to thank my panelists, and I'll welcome Steve to give us the next steps.
Well, thank you so much for our panelists who are welcome to take the front row here. And it's now my pleasure to welcome back Brennan Center's president, Michael Waldman, to introduce Senator Whitehouse. Thank you so much.
Thank you so much. Again, thank you to all of you. Thank you to our colleagues at the Brennan Center and the Kohlberg Center. We are quite honored to hear from our next speaker. The issue of the Supreme Court, of the Constitution, of the role of Congress, and how we can improve the system requires lawmakers who understand the law, who care about equality, who fight for ethics in government, and who understand how to use the levers of power and accountability for the public good. That is what we're going to hear from in Senator Sheldon Whitehouse. He is a senator from the state of Rhode Island. He is a senior member of the Senate Judiciary Committee, the ranking member of the Constitution Subcommittee of the Judiciary Committee. Before all this, he was the Attorney General of the state of Rhode Island, and he is a leading voice on the Constitution, on the courts, on corruption, and on Supreme Court reform. We're honored to have you here and privileged to support your efforts. Thank you so much, Senator Sheldon Whitehouse.
Thank you, Michael, and thank you to the Brennan Center. One of my links to the Brennan Center was a beautiful lady named Patricia Baumann, who was, I think, the chair of your board for a long time, and she was also the dean of the Natural Resources Defense Council, the NRDC board. So she and I overlapped on two of my key issues, government integrity and the climate mess. And I come here still conscious of her. She was the most elegant, delicate, polite person in her presentation. And she was just lethal. I adored her and I miss her keenly, and I'm happy to think of her as we go forward. So I think there are kind of two topics, two buckets that we need to think about the Supreme Court in. One bucket is education. I think many of us who've tracked what happened to the Supreme Court have a pretty good sense of it. I think there's a very abundant and clear evidentiary record to prove what took place, but we have not done a good job of actually communicating it. And particularly in the Biden administration, the reluctance of the bully pulpit to say one word about this really set us back, I think. So we've got some catching up to do in education. I think the sort of education topic areas, everybody needs to understand what regulatory capture is, sometimes also known as agency capture. It's a well-established doctrine in economics and administrative law, and it had its roots in the behavior of the robber barons of the 19th century who would capture the Railroad Commission to make sure that they got the rates that they wanted, or who would capture the Mining Safety Commission to make sure they got the mine safety regulations they want, and there is an abundant literature about it. Well, a couple of decades ago, a bunch of creepy billionaires figured, what the hell? If I can capture a regulatory commission, why not, raise our sights? Let's capture the damn Supreme Court. And they went about doing it. It began, I suspect, with the Powell memo, written by tobacco lawyer Lewis Powell, who then went on to the Supreme Court. And you can trace his tenure, you can trace through his tenure on the Supreme Court the gradual introduction and increase of corporate power into American elections. Was not a thing before. He slowly but surely inserted it and built it. And the culmination of his effort after his death was, of course, the truly disgraceful and corrupting decision in Citizens United. So that's kind of the frame. What took place here? A bunch of creepy billionaires decided they were going to capture the court, and they did. And you can lay out that scheme with some degree of authority. There are people who've done pretty good research into how it was accomplished. We even know that they spent somewhere north of $600 million that we can prove on doing it. That may sound like a lot of money, but let's just say you're a fossil fuel billionaire. And you understand that your industry stands on a $700 billion annual subsidy from the government from being allowed to pollute for free. That's not my number. That's the International Monetary Fund's number, $700 billion every single year. If you're protecting a $700 billion annual subsidy of being allowed against the laws of economics, against the laws of morality and against the laws of environmental safety to pollute for free? What's 600 million to build a court that will help you do it? So don't be daunted by the $600 million number. That's chump change to the folks who were involved in this. So you can follow the money. It didn't just go to the effort to build the court. They now have to execute on their scheme. And when they've planted judges on the court who are adherent to their wishes, how do you communicate to the judges what it is that you want them to do? They can't be expected to keep up. Some of them have been on for decades. They're getting old. You got to give them instructions. How do you do that? Well, you do that through amicus briefs. And you can track the creepy billionaire-funded amicus groups who turn up in cases that matter to them, usually in flotillas of about a dozen. The message is completely coordinated, but no disclosure about the coordination to the court. So it looks like this sort of spontaneous effusion of sentiment, when in fact, it's the same creepy billionaires speaking through a bunch of different mouthpieces, usually about a dozen. On big ones, like the Bonta case, where they wanted to establish that the 501c3 corporations, the charitable corporations, that they append to their 501c4 political battleships, can protect their donors. That one, at the certiorari stage, got 50 dark money funded special interest front group amicus briefs, 50 at the cert stage. So that communicated to the justices, guys, this is a really, really big deal. And just so you know, the 501c4 involved, the political hit group, was Americans for Prosperity, the Koch brothers' main political battleship in their massive political operation. The nominal plaintiff was Americans for Prosperity Foundation, an allegedly separate entity from Americans for Prosperity, but it's a corporate veil you could pierce with a banana. So that's the circumstance for that case. So you can track all of the different front groups. You can track the briefs that they filed. You can track the arguments that they make, and you can track that they are successful when they come in 100% of the time. Absolutely every single time. And you can track that record. And when you do, that gives you evidence of pattern. And back in the day when I used to try cases, you can establish quite a lot with evidence of pattern, particularly in discrimination cases alleging bias. You don't have to prove the scienter of the entity or the individual being sued that they intended to exert their bias and their discrimination. It's enough in court to get their record, their pattern in front of the jury, and allow the jury to make the logical conclusion from the pattern that, yes, that must be what's going on because it sure turns up every damn time. And so we need to focus not so much on what the court says about what it's doing, but about the patterns in what it's doing. It should be known, it should be a tell that every time this court makes a decision that affects or influences the political process, it affects or influences the political process in a way that benefits Republicans. Every time. It should be something people understand and know that every time this court make a decision that affects or influences the regulatory process, it affects or influences the regulatory process in favor of the fossil fuel industry. And we have whacking decisions like the Clean Power Plan case that individually prove the point, but it's really, really important to look at the patterns. If you tell the story of the scheme, if you tell the story of how the interests of the right-wing billionaire elite are communicated through the front groups, if you track all of that across these cases, and then you track the pattern of outcomes, that's a story that I would love to be able to take to a jury. You can win that. That is compelling evidence. So, this business of educating the public is going to be really, really important. And the only thing I'd add to that is that you can also look at anomalies where they say that they're doing like originalism, but they don't when it doesn't help with the outcome that they want. The Citizens United decision is the least originalist decision you could possibly imagine. If you want originalism, read the dissent in Citizens United. And that will prove that what they're doing is not executing on principle, but going for outcomes and using doctrine or not using doctrine as convenient to get to the outcome, which is why the talk about patterns, why the inquiry into patterns matters. And then kind of the cherry on top, just for the sheer merry hell and fun of it, is the Billionaire Gifts program that loads up the happy justices with emoluments that they can enjoy and usually don't bother to report, like family members' private school tuitions, like forgiven loans for $250,000 luxury family homes, like exotic trips on billionaire jets across the country with Leonard Leo to go salmon fishing in Alaska, like yacht trips on a billionaire's yacht. I mean, that all adds a really kind of additionally seamy but meaningful dimension to what is going on here, the rewards system for the most adherent and compliant of the judges. So education really matters. We've got to tell this story better. It is my hope that if Congressman Raskin becomes the chairman of the House Judiciary Committee in the next Congress, and if I become the chairman of the Senate Judiciary Committee in the next Congress, we can work together to put a series of hearings together that makes this case compellingly and effectively for the American people, so that they come to the same realization that those of us who follow this closely have already come to. But we do need to bring the public along with us. We have the evidence to make the case. We simply haven't made the effort, and we lost 4 years in the last administration. So how do you get out of it? Education is the one piece. The second thing is how do you get out of this mess? What do you do? Well, the investigation is really important. That's kind of foundational to being able to push through the other reforms. But the two reforms that are absolutely critical are a real Supreme Court ethics process. Justices were in yesterday talking about whether or not there needed to be enforcement, an enforceable ethics code. Let's not go there yet. Let's start with a way simpler question. Why shouldn't the Supreme Court have an inbox where an ethics complaint can be received? How complicated is that? Why can't the Supreme Court have screeners who look through ethics complaint, screen out the nonsense and the noise and the toxic, stupid, false stuff, and sort wheat from chaff and winnow it down to where there's a real ethics concern? They could easily do that. Why can't they, like the Senate Ethics Committee and House Ethics Committee do, have internal lawyers who then look at the legit ethics complaint and do an analysis? And here's the rub: do fact-finding. Way before you get to enforcement of an ethics code, you got to go through fact-finding. There are only 9 people in the United States government who won't subject themselves to fact-finding when a legitimate ethics claim is raised. They don't do fact-finding, which is particularly weird for the Supreme Court, the temple of justice, when fact-finding is the foundation of justice. But not for me? For thee, but not for me? If we got fact-finding, that would make a really big difference. If we got fact-finding, we would know whether Clarence Thomas ever paid his taxes on the $250,000 income he received from the forgiveness of the motor coach loan. If we had fact-finding, we would know whether he and his wife had discussed what was going on around January 6th when he sat without recusing on the January 6th commission case. We would know what was going on around Sam Alito when he took that trip out to the salmon fishing trip with Leonard Leo in the plane with him. We would know what was going on. And the court would know that facts would be found. And so they couldn't just blow it off. They couldn't just pretend that there's no question here, and therefore we don't need to answer it. So yes, an ethics code, what we call an enforceable ethics code, matters. But know that you have to begin with fact-finding. And when the Supreme Court says, oh, too difficult, can't figure this out, way too complicated, we're the Supreme Court, how do we let Junior anything else intrude? How do we sort all through all this? 50 for 50, every state Supreme Court has figured it out. It is not hard. There are 50 examples out there. The only hard question is really enforcement. Do you remove? Do you penalize? Do you censure? What do you do? Well, I will tell you my view, which is that if you have an ethics inbox and you screen and you do fact-finding about the ones that clear the screen, and then you have a panel, let's say, of the chief judges of the circuits, write up a decision saying, hey, if this were us, if this were on our court, wouldn't work. Here's how it violates the code of conduct. You don't need to enforce at that point. That, I think, is enough of a shock and enough of a deterrent so that the persistent mischief going on at the Supreme Court around emoluments, basically, ends. So don't get drawn into the argument about niceties of enforcement. There is no excuse for not having fact-finding, none. And every state Supreme Court has figured something out. So there's literally no thing that is stopping the Supreme Court from doing this other than their unwillingness to do it. And then it's term limits. And my bill is retroactive term limits, 18 years. So you start clearing the detritus immediately. And there's an argument to be made that a Supreme Court appointee has a life tenure, removable from the court only by impeachment. Okay, they can stay. You move them upstairs. And you let them wait for the constitutional cases, the ones that involve foreign powers or state versus state, or there's a very small, narrow group of cases that the Constitution requires the Supreme Court to hear. All of the stuff that we see them do every day, all of the appellate decisions that they make, Congress gave them that. They have no constitutional right to make decisions in those cases. They have the statutory right to make decisions in those cases because Congress said so and passed the Judiciary Act. What Congress can give, Congress can take away. So in effect, you have the retirees, the equivalent in federal court of senior status. Everybody knows how senior status works in federal courts. So after 18 years, you go up in senior status and you wait like the Maytag repairman for the constitutional cases. And you can be brought down when there's a conflict. So the court doesn't have to pretend that it has a duty to sit where it has a conflict of interest. If there's a conflict of interest, boom, you're out. Just get out. and bring in one of the upstairs judges waiting for the constitutional cases. It solves two problems in one. But you're not going to get there, I don't think, unless you've done the proper education and the people of the country understand exactly how this court was captured and by whom. Here's my last point, and I can't prove this yet, but I do believe that the evidence points strongly, strongly, strongly in this direction. Remember the Federalist Society list that Trump announced he would choose from in his first run for the presidency? The political context of that was that House of Koch, the Koch brothers' political operation, was at war with House of Trump. House of Trump was making fun of the Kochs, making fun of the other candidates who went out to kiss their ring at their fancy political conference. The Kochs thought Trump was disgraceful, corrupt, not attuned with any of their prerogatives and purposes. And that was a full-on actual battle. It suddenly ended. My hypothesis is that it ended with a truce negotiated between House of Koch and House of Trump, in which House of Trump said, we'll give you the Supreme Court nominees if you back off, if you leave us alone, if you stop. In fact, fund Republican get out the vote stuff for us. Help us. And the Koch said, yeah, we've been trying to capture that Supreme Court for a long time. That seems like a good deal to us. But we have a problem. We have a problem. We don't trust the bastard. He is a notorious scoundrel and liar. A private deal with him that he'll hand off his Supreme Court nominations to us? He won't honor that. How are we going to solve that problem? So Leonard Leo and Don McGahn came up with the notion of a so-called Federalist Society list. Public, pinning Trump down to that list. What do we know about that list? We know that the Federalist Society never considered it. It was never an agenda item on any Federalist Society meeting. It was never debated. It was never voted on. It was never approved. But it was extremely convenient camouflage to call it a Federalist Society list, when in fact, it was the Koch brothers list. It was the Leonard Leo list. You can't go to the public and go into elections saying, hey, I'm here, I'm running, and I've cut a secret deal with the Koch brothers so that they get to pick 3 justices on the Supreme Court for me. So you call it the Federalist Society list. And I think we need to dig into that and see whether my theory of the case proves out. And a good long debrief of Leonard Leo and Carrie Severino and the rest of his crowd of court-packing munchkins will reveal that. So that is the piece where I think the investigation side gets really, really interesting. And I would not be the least bit surprised if we got underway and subpoenaed the hell out of Leonard Leo, and it was an enforceable subpoena because it was a House subpoena, couldn't be filibustered, that he ran off to Portugal or someplace else rather than allow himself to be interviewed. So that's where I think we are, and I think it's really important that we continue this fight. We cannot be a successful country with a captured court that reliably rules in every political decision in favor of the Republican Party and in every regulatory decision in favor of the most dangerous polluters on the planet. Thank you.
Thank you. Thank you so much. Well, thank you. Yes, thank you so much, Senator Whitehouse.
I'm excused.
Thank you for being here. Thank you for your remarks.
Thank you all very much.
Well, thank you all for being here today and for this programming. The recordings will be up online. I just want to share some gratitude and thanks. First, I'd like to, of course, thank all of our panelists for being here today, for traveling from out of town. Thank you so much. I want to especially thank Jim Kohlberg, whose support made today possible. Our events team, Susan Augenbraun, Terrence Francois, and Brian Palmer were instrumental in pulling all of this together. I want to thank Kirsten Dunham and Robert Hogan with their federal affairs team, and also Kareem, Alicia for moderating these panels and helping us shape the day, to the Kohlberg team, Elazar Chacha, Ashley Masiolik, for all of their help, and our fabulous legal interns, Margot, Tara, Janelle, Matthew, Henry, and Molly, who helped us today, and our catering staff. As I mentioned, we have a variety of materials on that QR code. There will be follow-up. You'll have a follow-up email with links to these materials as well. Again, thank you so much. We are going to have a reception upstairs where you came in, and that will be going until about 5. So we hope that we can continue the conversation there. But thank you again for being here. Appreciate it.